Hello, everyone, and welcome. I'm really excited today to be talking about an extremely relevant topic that is in the news constantly and is of the utmost importance these days, and that is AI and the future of AI. Where have we been? What has happened in the last year? And where are we going? What's going to happen in this coming year with a special focus on privacy? We're going to talk a lot about ways in which AI and privacy clash, as well as all of the different developments that have happened. It's really dizzying how much has happened in the law and policy of AI over the past year and what's happening right now and what's to come. It is truly overwhelming, but I hope that we'll be able to make sense of some of it and make some predictions for what is likely to happen this year. So with me, I have two real experts in this who have been following things very closely. Leila Golchehreh is the co-founder and chief strategy officer of Relyance AI. And Alexei Klestoff is a attorney at ZwillGen, focusing on AI as well as platform liability issues. So I'm really excited to have you both here. And I'd like to start actually by just catching things up to where we are now, which is what happened last year. And I guess briefly, in your view, what are some of the most significant developments that we saw in privacy and AI in 2004?
So, I think the most significant thing is that regulators and legislators have started to catch up. They figured that they need to do something about it. I think I, I read somewhere where there were about 700 bills considered for AI laws, and about, by my count, I think it's like 60 that got passed. There And the interesting thing is, which I think is kind of unique to AI, is that most of these laws focused on very narrow use cases, right? With some exceptions, there it was a lot of deceptive political content, deepfakes, revenge porn, things like that. Kind of like the obvious, the low hanging fruit, and then very few of these laws, are of general applicability. And actually, like I don't think I've actually seen a law that is sort of similar to the CCPA or the GDPR in a way that applies to everything. Even Colorado's AI Act is limited to a very narrow set of use cases. Same with the EU AI Act. They're mostly focused on high risk AI, which is sort of, again, it's the low hanging fruit. Employment, education, surveillance, things like that. So I think that there was a lot of movement, but I didn't see any like a giant paradigm shift in like how AI is going to be regulated. The FTC was pretty busy. They jumped on the AI train for pretty rapidly, which is going to change considerably. I think now that Andrew Ferguson's taken over, I think one quote from his agenda was he wants to end the FTC's attempt to become an AI regulator. So I don't think the FTC is going to be that big of a player going forward. And then, the privacy regulators have really, EU privacy regulators in particular have really stepped up. I think the Garante, Italy's privacy regulator, has been pretty active. I think they were first to investigate OpenAI. They've investigated sales of data to OpenAI, and just yesterday they opened an investigation into the new kid on the block, DeepSeek, the Chinese AI model developer. So there's a lot going on. I mean, I think that's I think that's going to shift going forward. But there's everyone's catching up.
Leila, what are your thoughts?
Yeah, no, I agree with everything that Alexei just said. We continue to see the EU regulators leading the way as far as developments, not only in data privacy, but also because of the EU AI Act. I think that was kind of all the talk of 2024. From an operational and just like a technology landscape perspective over the past 2 to 3 years, it's been all about just generative AI, large language models. I don't think I was in a panel or discussion or talk last year that did not mention the words generative AI. So I think that was the entire focus of 2024, and generally how large language models are going to shift the landscape. What are the privacy considerations when you're dealing with these tremendous amounts of data? And I think we haven't really understood yet what real value means, but we're in the hype cycle. I think we've started to see things like more developments in AI in addition to Gen AI and LLMs, but agentic AI I think is going to be really, really interesting. I do, kind of see that sort of future forward. We can talk about that more later, but I think, everything that we have seen in 2024 has been about understanding what we're even dealing with. I think, Alexei, you just said that regulators were really trying to catch up. I think regulators are still trying to catch up. And then you mentioned DeepSeek. Now we have challenges with open source AI coming out of China. What are the privacy, security, and governance related questions that we're going to have to address when we're dealing with more open source? And I think once we get out of this hype cycle, we're really starting 2025. And I think every kind of CEO mandate, every company should be assessing how do we operationalize this hype cycle into actual use cases that are going to have real outcomes and a true impact on the business. So lots more to say on that, and I think lots more to come.
Yeah, everyone wants to say they do AI, whether they need an AI application or not.
Exactly.
Yeah, I think I'll weigh in briefly here. I think that there's kind of a lot of there is a lot of hype here. AI has been with us for a very long time. And it's only recently that it's become so supercharged in the media and everyone's talking about it. And it's had clashes with privacy for a very long time. I actually have a paper that's coming out in really just a matter of a few days. A draft is already online and the final version is coming out, a paper called Artificial Intelligence and Privacy. And basically what I'm arguing, and I still believe now, is that a lot of the privacy issues with AI, and there's a lot of them, were with us for a very long time. And so we want to avoid what I call AI exceptionalism, or just thinking that AI is somehow so unique that it's totally separate from these issues. And a lot of the problems with AI and privacy are problems that the existing privacy laws should be dealing with, but are actually very ill-equipped for dealing with. So a lot of these problems play on a lot of the weaknesses of the existing model of privacy laws. And that model has been to try to give individuals various rights in their data and try to somehow give individuals control over their privacy. And I've long thought that it's too complicated for individuals to have control. And I think AI really drives this point home because AI is so complicated and will come up with decisions about people and inferences about people that people really can't understand and be able to predict at the time they say, yes, I'm going to share my data. So people really can't make a good risk calculation about whether or not when they give up their data or allow a certain use, what the implications are going to be for them in the age of AI. And that's really a problem that's been in existing privacy laws for a very long time that needs to be addressed. And so last year we saw attempts to try to regulate AI with these separate AI laws. What we didn't see, which I think is disappointing, is a call to rethink existing privacy law to address a model of regulation of privacy that does not work, that hasn't worked, and that AI is really driving home just fails. So we have these new AI laws, and I'm not sure that they really, I like the fact that they focus on risk, but I'm not sure they're really doing all that much. So that's my take on them, is that, it's interesting first stab with the EU AI Act, and we saw Colorado, but I'm just not sure like how big of an impact the laws that we're seeing are really having on these problems. I don't know what you think, but I kind of think, well,
I totally agree. I mean, I think that despite all the hype about the EU AI Act and the Colorado AI Act, like I said before, they apply to very narrow use cases, most of which these aren't the use cases that most companies are thinking about. I like your perspective on, it's not that privacy laws don't, like, it's not that AI doesn't fit in privacy law. Law doesn't fit in AI. Like, I think you're right. There are a lot of super interesting questions that have come up with AI. I mean, scraping's been around forever, right? And the fact that it's being done, and it's been done on massive scales before, and the fact that privacy law there hasn't been a ton of guidance, like regulatory guidance or cases about what that means, like what the privacy implications for that means, is interesting. And then, in terms of data subject rights too, right? Like, how do you train, if you're using a model, using personal data to train a model, like, what happens if someone deletes it? And I think this is really, really interesting, because like, you can't retrain a massive large language model every time someone asks you to delete their data. It's gonna be like that scene from National Lampoon's Christmas Vacation. The power's gonna run out of wherever the data set, it's gonna shut the lights off in an entire state. Which the environmental impacts of AI is like a whole other thing. But there are really interesting theories, and there was like an EDPB expert opinion that got published, I think, last week, about the different ways to potentially address this, right? Like federating model training, training little models that feed into bigger models, and then you only have to retrain the little model. Or interesting, like, statistical things where you can get the model to forget the data. The data is still going to sit in the data set, but it just will never spit it out. And the EDPB opinion on like whether a model, which is just statistics, is anonymous too. I thought that was really interesting too, because it makes you start thinking about, like, what does this actually mean? Like, if math can spit out personal data, is the math still personal? Is personal data itself? And it seems like the EDPB is saying yes, which I think is it's kind of, I don't know, what the ramifications that has for anonymization generally is, like, who knows? But
you have a lot to say on scraping, but I wrote a whole paper on it, like pages, and like 60 something pages on it. But I do want to get Leila's take on the laws that we've seen. What do you think about them so far, as kind of the initial regulatory blueprint that we've seen?
I think yeah, it's a great question, Dan, and I want to double click on what you said about just generally having our privacy laws apply to AI. I think that is probably the right approach, and I think, just as we saw with GDPR, setting a stake in the ground and then setting off a domino effect across different jurisdictions as far as building their own privacy-related programs, we're going to see the same with the EU AI Act. We already are. Of course, we have other frameworks like ISO 42001, setting kind of like the first AI framework. This is something else that we can be considering. But I think we are looking at, generally outside of the EU region, or for companies doing business in the EU, really looking at the principles that can apply here. I think 2025, if we just think about what we should be prioritizing as we look forward, 2025 needs to be the year of observability. We have been kind of trying to chase down what's happening with other teams within businesses. But lawyers, especially regulators, really need to understand the environment. The fact that a Chinese startup that allegedly only invested 6 million in order to build this model could wipe out 600 billion in market cap in a single day really demonstrates that we are facing a moment in AI that is showing that things are going to change rapidly, that it is going to be very difficult for us to keep up from the regulatory and legal front. And that to exactly the point you were making, Dan, it's going to be critical that we understand what we already have in place and see with respect to data privacy and how we can apply similar principles: transparency, notice, consent. And of course, we have all these new things we have to worry about: hallucinations, deepfakes, bias. But generally understand how we can build and measure an observable program that's going to allow us to act no matter what the changes are in technology and no matter what the changes might be in the regulatory landscape.
Yeah, and I think that there's so much there to dive into. My goodness, it's like I don't even know where to begin. I'm like this buffet. I think on the laws, and you mentioned, the various principles of privacy that we've kind of tried to rely on as a touchstone for so long. Were privacy laws, transparency, notice, consent. Unfortunately, a long strand of my work going back for 10 years is like these aren't bad, but they don't solve the problem. And so we keep going back to like our foundation, but it's not enough. And I think AI really shows that we need not just stronger privacy laws, but a kind of a pretty radical new direction, a new dimension to privacy laws that is going to be very different kind of thinking about it than we typically do, which is, well, we just make consent a little bit better. But I don't think people can really consent to things they have no idea and can never understand, like AI. Typically, I think, right? Is this new product? Is this new service? Is it going to help me more? That's going to hurt me, right? Am I going to get more benefits than costs? What's the risk? What's the benefit? Let me decide. And they're going to make this decision very quickly in a snap. And the problem with AI is, well, I can't really assess what the risks are. I don't know what data could be inferred. My consent is not going to be meaningful if I don't really understand what I'm getting myself into. I can't make that risk balance. But that changes and that kind of blows up a lot of the existing frameworks that privacy law is built on.
It's so true, Dan. Oh, I was just going to add on one thing you said. I mean, I think that's absolutely right. And I think what DeepSeek did, and some people are saying this is all just hype, but I think the impact of this shows that we are absolutely in an AI space race. And for us to be thinking about governance, privacy, security, and generally what our controls are while we're in an AI space race, I think is going to be one of the greatest challenges that the profession faces. Because if we are seen as slowing down any United States company, and as Trump kind of is positioning it as that space race is against China, it may be a hindrance to businesses. And I think that's going to be a big question: is how do we embed in those workflows to facilitate, if you are sitting in the US, kind of winning the AI space race, but still implementing the correct governance controls.
That's a great point, because I think that's a really big issue that goes to the heart of even the willingness of policymakers to pass the appropriate laws, because I call it a myth that technology stifles innovation, but it's been with us, and we hear this argument all the time. Well, if we strongly regulate, then we're going to lose out in the AI race. And I think this is the kind of ideology that the current administration has. We're in a sprint with against China to develop AI. So if we regulate, we're going to kill our AI industry. And I think this is a myth, because essentially it means like you can't really do much meaningful to regulate here. I think that there are, and this gets back to scraping, and the piece I wrote about scraping. I mean, a lot of the AI companies got their data because a lot of it's personal data. They just went and took it. And general ethos is take it, do whatever you want, and then worry about the consequences later, because it's better to ask for forgiveness rather than to ask for permission. And they think, oh, it's publicly available data, therefore it's just free for the taking. I think, and I wrote in the paper, no, it's not. Even though a lot of laws in the United States have publicly available information exceptions, those exceptions are actually different shapes and sizes, so they're not. Some of them aren't blanket exceptions. So there could be legal violations. I think it's a violation of GDPR to take this personal data and scrape it. I think it's also generally inconsistent with the basic principles of privacy. Every single privacy principle is violated by scraping. Data minimization, data security, secondary use restriction, providing individuals with transparency and notice and consent, and all of every single thing in privacy law is essentially ignored with scraping, because it's just like, this data is in a privacy-free zone. We can just take it and do whatever the hell we want with it. And what we argue in the paper, I wrote this with Professor Woodrow Hartzog, is there needs to be a reconciliation. Like, this just can't stand, that there's some very strong arguments and precedent mixed in the United States, but even stronger in the EU and other places in the world, that say, this is not okay, and we need to figure out how to reconcile scraping. And also the companies and sites that put this information online have an obligation to use measures to try to make it harder to scrape. And there are measures beyond just saying, don't scrape in the terms of service. There are ways that this could be done. And I think with the story that just broke, right? Where did they get their data for this new model in China? Well, they just scraped it. Well, we don't want them to take it. The sites have to have an obligation to protect it, like LinkedIn and other sites where a lot of personal data can be grabbed, or Reddit, or Meta, or X, or other sites. That's where this data sits. And so I think the law, and this is a privacy law issue. This is a privacy law problem. This weakness in privacy.
Sure is. And an intellectual property issue as well, Dan. I mean, totally agree.
I'm not sure I'm that bearish on the scraping issue. I mean, the Keneal, it published like this really, really interesting, like big detailed set of guidance. And they talked about scraping and various ways you could do it. You could potentially do it in compliance with the GDPR. The EDPB's opinion on AI and legitimate interest and all the other things also kind of contemplated the possibility that scraping isn't a per se violation of the GDPR. Again, this is privacy law, trying to adapting existing privacy law to this unique use case of AI. But I think it's possible. Another thing to keep in mind too, this isn't like a justification, but I think most of the internet's been scraped already, right? Like, that's why companies are licensing data from news sources and other like high quality data sets. So and there has been a trend to smaller models, right? And so I think, again, this is more practical than like a justification for any potential privacy violations. But I think in the real world, the things are changing really, really quickly. So it'll be interesting. I think the privacy regulators are going to be looking at practices that may not even be live anymore.
Yeah, I think that, and yeah, I think ultimately the regulators, I count on them not to really take the kind of stand like I would take as an academic. They will, like, they're not going to, the EU's not just going to ban scraping, and so they're going to find some compromise. Actually, I have a cartoon that I wrote that I haven't released yet, where this person's like just taking everything from like all this paper from like what looks like an all-you-can-eat buffet, and then this cop stops them and says, "Hey, what are you doing? You can't just take all this." And so, well, it's for AI, and then he's like, "Sure, I'll go ahead." We'll just let you do it. And I think that's what's going to, and it goes to what you mentioned earlier, Alexei, on the, deletion of models. I think that's really theater, because all those cases are ones where the company agreed to do it. There's settlements to the FTC where they're agreeing. But I dare the FTC to say, like, delete the latest model of ChatGPT.
Oh, I'm not talking about deletion of the entire model. I'm talking about deletion of an individual piece of data in a training data set. Say I want Alexei Klestoff to not be in DeepSeek's training data set, and what they have to do to actually make that right effective. So
and I don't know how we can get ultimately there's a really interesting paper by Professor Tiffany Lee on that when you just deleting a person's data doesn't really remove their like what it learned from them. It's not so easy to unwind, and there's what she calls a shadow that still exists. So it's not clear like that scrubbing is going to work, and unless you do it in mass, it's not really going to have a big impact. So I just wonder, is that remedy going to be? I'm just not sure it's really going to be a meaningful remedy or a practical remedy at the end of the day. Like, I think that's not like.
But what would be the alternative? Right.
The alternative might, Alexei, be try to obfuscate that data before it's put into the model to begin with, and have methods of obfuscation or trying to remove those personal data elements to not have to deal with the problem in the first place.
I mean, regulators say that all the time, but data scientists I talk to.
Easier said than done. I understand. The implementation of the things we're talking about is a very different question.
But what I'm interested in is like what the alternative is. Is it like everyone gets to license out their own personal data for AI model training if they want to? Is there going to be a giant marketplace to be like, sell my name, sell my email, sell for I've struggled to come up with a solution that is different. Maybe just.
Well, I think it's also, Alexei, I think it's also about the use cases, right? So we have the EU AI Act explicitly prohibiting things like that Clearview, explicitly taking biometric information in order to train models. And I think it's not just about the collection of data. I think we also really need to consider the use and output. And kind of back to the point I was trying to make about the themes that I see taking hold in 2025. It's all going to be about, do we actually understand what we're doing? Are we measuring it? And are we trying to implement? And I know this falls short, Dan, of what you would like to see, and I totally appreciate that, but it's what we have now. Can we start to implement frameworks like NIST or ISO, or at least some of the main principles that we're seeing out of some of these global AI, laws and regulations that are being put out. And if we can start there, and I do feel like that was a pretty fair prohibition from the EU AI Act.
I don't think anyone. I don't think anyone will disagree that pre-crime, despite what Argentina wants to do, would be predicting crime and arresting people because they might commit a crime is using AI to do that is it's not something that should be banned.
Correct. And I completely agree. And I think that's going to be something that I think of the different things that I think this new Trump administration is going to be focused on. I think national security is certainly going to be top of their agenda. We're already seeing this proposed as one of the key priorities of this administration. I think some of these different not only the his focus on immigration, but also we're going to see AI used in ways that are supportive of what Trump sees as national security priorities. I would also say for 2025 that energy policy would be one of the key strategic priorities of the Trump administration. That said, I think DeepSeek is showing us that every company, even if this might be kind of one of the Trump administration's priorities, every company, except for maybe not NVIDIA, is looking for ways to make AI as efficient and using sort of the least amount of GPUs possible. And I think that we will see from industry more and more attempts to build more efficient AI models, which is actually great news if you're an environmentalist. I think there are still questions that will linger as far as as we make these models more efficient, are they becoming less transparent? And I think as a profession, as privacy and AI governance professionals, it is going to be a big question that lingers when we see such dramatic changes. If you are of the camp that thinks that DeepSeek did show progress, is this going to make an impact on how we actually govern these types of programs?
I'm a little skeptical of the hype in that everything, as you say, is an overhyped area, and so how is DeepSeek really done as cheaply, or was there some financing that we just don't know about there?
Or was it trained on the backs of
$500 million
yeah,
500 million in GPUs for the earlier models. So 6 million. If you spend 500 million to only spend 6 million to train your, next time.
The Chinese government loves to help out their industry, and it'd be shocking, like they barely funded it. I don't buy it. I also don't buy, the energy issues too. I agree with you. I think that's going to be the next challenge is, how do we do AI, an environment in a more environmentally friendly way with less resources, although the current administration's answer is drill, baby, drill. So I don't know where that's going, but it raises the other issue, like we're now in a new climate, right? Trump comes in and rescinds the EO and kind of declares, as you mentioned, Alexei, too, through the new chair of the FTC has said, we're not going to regulate here, and we're in a kind of deregulatory area.
Guess who is, Dan? The California AG, the Oregon AG, and hey, even Texas is like in on it, which is, I didn't have that on my regulatory bingo card. That Ken Paxton was going to be like a big privacy or an AI regulator, but I think these states are going to step up, right? California's automated decision-making regs will probably have a big role in this too. As to paraphrase, it's like as California goes, so does the rest of the world, or the states at least. So I think the California or state regulators are going to step up. I think everyone has this it's not just your C-suite that wants to do AI. Regulators want to do AI too. So both the Oregon AG and the California AG published a bunch of advisories that said, hey, we may not have generally applicable AI laws, but guess look at all these 20 other laws that apply here. So you're on notice. And if you think that California AG isn't just going to stand by and do nothing, you haven't dealt with a CCPA investigation yet. So I think that's what's going to happen. Everyone wants a piece of this.
I think that's another good point to raise, Alexei, is that I think especially as lawyers and policy professionals are looking at regulating AI, it's very important that we learn ways to adopt AI into our own lives. How can you regulate something if you don't understand it? And I think for 2024, it was a lot of just catch up, but I do think it's going to be really important that we start to implement. So that means that lawyers, policy professionals, regulators, governance folks are all going to need to start to figure out how to apply theory to practice. I think this is really the year where the rubber starts to meet the road. And not only from the how are we actually governing in this perspective, but also from the perspective of what use cases do we see within our organization to actually make things more efficient across the board. And we will also need to see kind of just the speeding up of AI adoption into our own workflows. And understanding generally how departments within organizations are really going to work cross-functionally to establish, controls and a framework for managing this. If not for a federal law, like you said, Alexei and Dan, we will see, states starting to take the lead. Certainly, I think it starts in the EU, then it comes to California, and then we have a domino effect. We've seen that repeatedly with chemicals regulation, with privacy, and I think now with AI as well.
Yeah, I think that the federal government's kind of fooling itself if they think, oh, we'll just deregulate and then it's all okay. I mean, the states are going to fill the void. All they're doing is basically taking away their own leadership position and kneecapping themselves as a major voice in how AI is going to be regulated. Essentially, the rescission of the EO and the statements being made by the government is essentially saying to the world, like, hey, we're not going to be part of this conversation. We're just going to be the kind of annoying gadfly on the side that says, hey, don't do anything. And that's not really going to be very effective. I think at the end of the day, the states are going to do their thing. The world is going to move and do its thing. And it's just now going to be without, much, input from the federal government, from the U.S. So we've kind of just taken ourselves a little bit more outside of the conversation, but it's not like we're creating a big regulatory void. Another problem I see too is that AI is so many different things. I mean, it's like the internet. It's such a wide array of different uses and implications for different things that it's hard to kind of come up with a one size fits all AI law. It's kind of like regulating
100%.
everything. And so that's such a problem. That's such a difficulty. And I think, just privacy alone, kind of, there's a lot in the privacy laws. And then there's issues of, as you had mentioned earlier, Alexei, the Minority Report issue of, from the movie Minority Report, predicting future crime, and the use of AI in the criminal justice system, which presents a whole bunch of issues. There's bias issues. There's issues about safety and national security. And each one kind of is dealt with in these other laws and to some degree, and different uses of AI have different implications. Some we might want to ban. Like I personally think, Clearview AI in the things they're doing is deeply troubling and should either be banned or, dramatically, regulated to a level, that is 1,000 times more than it is now. I think it's very troubling. I think they went and really flaunted the law constantly. And so actually I'm kind of in favor of just shutting them down because of the kind of blatant violations that they did to kind of get where they're going. And we're seeing a little of that happen. But I think that's a different case than other uses. It's a different case than Gen AI, and it's very, very hard. And I think that was also a big struggle in the EU AI Act was, what to do with, all, multi-purpose AI.
They just bolted that on at the last minute. And
that's the ball game. And for a lot of AI, it's AI that the user, can decide, how it may be used. And that could be an infinite number of uses, which then becomes really tricky. Well, how do you regulate that? And the way they try to finesse the issue is a little bit absurd. I think they just finesse it to irrelevance. But that's the problem. You're going to have to not just regulate the AI creators, but you have to regulate the AI users. And then the AI is also created not just by like one. It's not like one company, creating it.
Right.
puts out a model, and then other people adapt to the model, and there's various additions. AI, it's almost like a village to create these models, and then they're the users that will further adapt them and use them. So it becomes really unwieldy to regulate when we have to regulate a village rather than just like one single entity.
Exactly.
If you
Well, I have concerns about just generally with all the challenges we already face with the technology stack, how from a regulatory perspective we can actually have harmonization to the point that we're not all talking about different things. That was always the challenge, even between the GDPR and CCPA. I mean, why couldn't we just use the same terms, make things easier, instead of having to have two different pieces of legislation when so many of the principles were similar? Like the goals of the regulators, I think, were very aligned, but the terminology was just different. And Dan, you were talking about providers and deployers or users of AI systems. And I think this is something that we should, at least as an industry, begin to align on terminology and our agreements, just to make our commercial lawyers, make their lives a little bit easier. So we're at least talking about the same thing. And when I talk about one of the main themes of 2025 being observability, it's not just understanding how we are talking about AI. What are the terms we're going to use to describe the players involved, how models operate? But let's standardize on things like what needs to be in a model card. What are the absolute first principles? And I know, like I said, Dan, I know it falls short for what you would like to see in the way of regulation. We probably do need something new, but let's look at what we have and begin as an industry, and without real federal leadership from the regulatory perspective, begin to harmonize across not only US states, but also the world. And then, from a second point that I want to make, just from the observability within your own environment, there's only so much we can control right now. So I think what's really important is that we take control of the things that we can understand and control. And that's what's happening within our own house. Everything that's happening outside, whether states outside of Texas, Colorado, California are going to start building new state laws, we understand what's going on in our own environment. Do we have data lineage? Do we know where our data is coming from? Do we know what is happening within our own AI models? Do we know who is accessing the model? What's being done with that information? And how are we measuring what we think are important governance controls? For example, can all agree, I think, that hallucinations are not good. It's not good for the model. It's not good for the company. It's not good for trust. It's not good for business. So if we are agreeing on hallucinations being a problem, then let's make sure we have a way of measuring whether or not we are successfully ensuring hallucinations are outside of our models. Same things are true for fairness and bias. Despite the repeal of a lot of DEI initiatives at the federal level, you're still seeing companies, Costco, Apple, that are still going to have these types of initiatives hold true within their of AI with respect to this? How are we thinking about it from an AI perspective? Are we going to continue to prioritize bias? And by the way, not just from a DEI perspective, but bias, if not done correctly, can cause security risks. For example, if you have a threat actor who is attacking your infrastructure, but because of bias embedded in your model, you only think that a threat actor might be coming from a group of 5 countries. You might neglect to investigate other potential threat actors that might actually be causing these types of issues. So I think there are certain principles and themes that we've seen out of the different frameworks and the EU AI Act and different state laws that we need to align on, and make 2025 the year that we actually have a path forward as an industry together.
I think there's ways to do some of this. I think bias, fairness testing, and red teaming and things like that. Those are all there are existing methods to do that, and the statisticians and the data scientists are getting better at that every day. And in terms of hallucinations, I think it's sort of it depends on the use case, right? Like if you're trying to target someone for a drone strike, you kind of want to be right, as opposed to like, am I asking ChatGPT like, hey, is this restaurant any good? Right? Then I don't really. Okay, if the restaurant doesn't exist or it's closed, all right, that's about as good as Google gets. And there's other ways to. I mean, there's ways to sort of in the middle is like. It's called RAG. I can't remember the first, like retrieval augmented generation, where it's, you have it base its answer only on the things that you give it, right? You upload the EU AI Act and you tell me like, hey, give me the 10 things that you need for general purpose AI models. The hallucination risk decreases considerably. I actually think it's super interesting. This is like less privacy related, but more in the existing law, how this will work, right? Like CDA 230, who's the information content provider, right? Like it's not just like I'm posting something on Facebook. What does that mean for AI models? Can you sue a large language model provider for defamation if the thing spits out says like I murdered someone yesterday, right? These are like very interesting it's like square peg round hole legal issues that that AI is sort of like sussing out. I think it's all this stuff is, and who knows where CDA is going to be at the end of this year, but
those issues, I think, on the issue of debiasing an AI model, I mean, that runs into privacy law because, issues of, race and ethnic origin are sensitive data under most of the laws, and they require opt-in. There's a lot more restrictions on their use, which then makes it harder to use them for debiasing. And that's, I've long said, that the approach of privacy law, which is to try to think that there's somehow inherent qualities in data rather than focusing on use, is just the wrong approach. And that impedes that use. So if we focus on use, we want the use of this data to debias these algorithms. We just don't want the use of the data in ways that could harm people. But if we just have a kind of one-size-fits-all law that says, well, we're gonna make it really, really hard and put all these restrictions on using this data, even if it's for a good use, then we impede, the ability to debias the AI models. And then on 230, this has long been a big sore spot in the law. The courts have interpreted that in incredibly broad ways, and much broader than it was written. And now we have net choice that's sort of making arguments out of two sides of its own mouth. In the one hand, it goes and says when it's challenging content moderation laws, it's saying, look, we're speakers. We are speakers. We have First Amendment protection. And therefore, we're speaking with what our algorithms are doing and how we're moderating content. Then they turn around for 230, which immunizes a platform for the speech of others. Then they say, well, oh no, it's not our speech, it's other people's speech. Our algorithms aren't speaking, and we shouldn't be deemed to be speakers under 230. So what our models put out and what our AI does to moderate, that just is not speech under 230. And I'm going to think, you can't have it both ways. And that's what there's a great case in the Third Circuit against TikTok, where the algorithm served up a video that was this choking game. You choke yourself and see how close you can come to dying, and then stop. And the algorithm served up this video to children. And there were complaints about it, and they didn't really do much about it. And then they got sued, and the court said, well, look, you've been arguing all the time that you're speakers, and you served up this video to an 11-year-old girl who in fact followed the video and died. You can be liable. So I think we're going to see some pressure on 230 as I think
from both sides.
Yeah, I think courts are starting to realize, the existing 230, kind of very, simplistic and absolutist type of interpretations are not going to fly anymore. So there's another area of sore spot in the law that I think finally, the question is going to be pressed to the degree where we're going to be forced to really finally rethink this.
Yeah, but I get the practical implications of CDA not applying to like recommended videos. I'm actually not sure what that means. I mean, in some cases, like if you can't guarantee that someone's not like a harmful video is not going to show up, do you just not have recommendation algorithms, and does that just like ban them outright? Or I mean, that's like the logical extension, but like I think
you need a fault standard. I mean, it would be a fault standard. It wouldn't be like anytime an algorithm does it, it's a strict liability regime, but it would be ordinary tort law has tools to deal with this. And that's sort of the tool is, that you look at, what's a reasonable standard of care that's based on, what's possible, what's technologically possible, what others in industry are doing. And so if it's the case where it's really not possible to, screen out every video, we would say no. But if it's clear in the case that, the algorithm is not being careful, there are ways that it could do better. Others are doing it better, and it's just that the company doesn't give a damn. Then I think that's where the tort liability works. And it's generally an argument. I have a new book coming out on privacy and technology about this question: can law ever keep up with technology? Can we do it? And I think yes, because we have this technological exceptionalism, and basically we have basic tort law has kept up with food safety, and we've kept up with car safety, and we typically if we have standards of care and the law evolves, and we hold companies responsible if we don't think they're following a reasonable standard of care. But with technology, the law throws up its hands and says, oh no, we can't possibly do that. We'll just have to immunize them and let them do whatever the hell they want. I think we'll know if we just apply the law. Don't let technology kind of make us like lose our minds or freak out in abject fear that if we try to apply these things that somehow we're just going to like break the internet and wreck technology and lose the AI race. I think we can have lots of innovation, but then hold companies to a standard of care that's reasonable, and that's I think that's what 230 impedes a lot of times.
I think I have like two reactions to generally what you said here, Dan. So the first is, one of the other big things that happened this year is that, Mark Zuckerberg announced the removal of content moderation. And I wonder, and I think it'd be interesting to discuss, is that a reasonable standard of care in general? Are we going to accept that as being reasonable when there are videos and algorithms proposing choking games like what you just suggested? And then the second kind of reaction to what you said, Dan, is that I think absolutely technology can keep pace with technology. And by that, I mean, we can use legal privacy governance technology to embed in the workflows of AI companies to keep pace with what they're doing. But we cannot do that without the use of technology. There is absolutely no way that as a legal profession, we can think that our Word documents and Excel spreadsheets can keep up with the incredibly fast pace of how AI is being developed. But I would love to dig into the content moderation piece, because is that going to be the new standard of care? Are we going to accept community regulation as being reasonable to ensure that things like hate speech or dangerous activities like the one you were suggesting, or things that could be risky to our own democracy, can that be moderated by the community? Is that the new way forward in 2025 and beyond?
Yeah, Alexei, what do you think?
Well,
skeptical.
I don't know. I mean, I think number one, I think it's easy to look at CDA and things like online advertising, which is another like hot button, privacy hot button now versus in the 90s when I was listening for the You've Got Mail on AOL, right? Like I think the internet would have been a very, very different place if there was no CDA and you'd have to pay for all the different services. I mean, I think for better or for worse, but I think I think I tell whenever my kids complain about an ad coming up on Spotify, I'm like, well, we get it for free, so they show us. That's how they pay for the service, is they show us ad, or they play ads. And I think some of this is because of the benefits of this is that we have the internet as we know it, again, and the downsides is that we have the internet as we know it, right? There is the ad tech has, like, there are consequences to ad tech that can be problematic, right? And there are, I don't know, I'm a privacy lawyer, but like I could use a relevant ad. I don't really need ads for things that have no relation to me. Same with CDA, right? I think the content different companies take different positions on content moderation, right? Like X takes a very different position on content moderation than some other companies, and I don't know. I struggle with, like, okay, do we need a legal regime to make companies do this, or do we just need companies decide, like, make internal decisions about what they do? Like, I don't really want a neo-Nazi social media network, accessible to anyone on Earth, right? It's a really difficult question here.
Yeah.
And
I think let the liability system do it, right? They ultimately, in ordinary situations, someone makes a product that harms people, they get sued, and the lawsuits drive accountability. I mean, if you do nothing and just say, hey, free for all, do whatever the hell you want, there are going to be companies that are going to do whatever they want, and they'll get ahead doing what they want, and they'll harm other people and foist off the costs to the people they harm. And yeah, if I can drive, 150 miles an hour down the road, then great. And I can be reckless, then I can get where I want to go faster, great for me. But, we say in society, you can't do that. You harm other people. You should internalize your costs. And I think that.
But should the car maker be liable for that? I mean, I think there's like a.
And are AI models a product? I think that's the other big question I think we should talk about, because I think there's been some, some controversy in the courts, and generally there was a case out of New Jersey that is saying maybe AI models are not so much a product. So where are we even landing if we are going to set a liability regime? Dan, how do we classify AI models? Are they products such that we can apply, strict or, other types of tort liability regimes to their malfunction?
It's tricky. I mean, I don't have all the answers, but I do, generally with cars, right? I think it's, sometimes a car manufacturer will be liable, sometimes not. If someone's just speeding, it's the driver. But, let's say the car, let's analogize it today, it's platforms, right? The car doesn't just have, you hit the gas and the car says, you should go faster, speed, speed, speed. I don't think there are cops around, so speed, go faster. Actually, we'll help you. We'll give you speed boost. We'll, in fact, inject dopamine into your body so you go faster. We'll do all sorts of stuff to help you. And that's the difference. And I think that would make someone more responsible. But it's very much depends on kind of what they do and the role they play. I think CDA 230, for example, is totally fine the way it's written. I just don't like the way that the courts have interpreted it to go way beyond what it actually says to make this kind of blanket immunity, where I don't think CDA was an absolutist immunity. It was actually a law that was trying to encourage content moderation, not immunize companies to do whatever they want, and not have content moderation. But that's a whole other ball game. But reining this in, because we're about to go about at the end of the hour on AI, real quickly to end, I guess, fearless predictions. What do you expect to see? To wrap it up, what do you expect to see this year? What's your thought of what are we going to be talking about in December 2025?
It's going to be the year of the state AG. It's going to be, same with privacy, right? If you're still waiting for a federal privacy law, don't hold your breath, right? And so I think, and we've seen we've seen California and the CPPA be really active in privacy enforcement. Yeah, I mean, Texas, right? Like about as red and blue as you can get, right? So I think that's what's gonna drive AI enforcement.
Yeah, I agree with you, Alexei. I think state laws are going to be critical. I think also globally, we should be looking at what the rest of the world is doing to also influence how states are regulating. I agree with you. We're not going to see a federal AI law, or if we did, it'd be relatively weak. But my other sort of key themes of 2025 are observability, not only from the legal landscape, but the technical landscape. We need to understand what's going on in our own house, understand the things we can control and act on them, and actually implementing governance programs, not just talking about themes, but actually providing practical implementation steps at companies, whether it's through model cards or otherwise, to make sure that we have true ways of measuring the success of our governance programs.
Yeah, I think that's a great point. I agree with both of you. I think, the states are going to be where action is. The rest of the world, we're going to see action. We might see some attempts at something federal, but probably we're not going to see anything meaningful happen at the federal level. But we are going to see a lot of action at the states. But I think Leila's point that I think is very important is, companies really, shouldn't just kind of be sitting and waiting for well, what are the states going to do? What's the world going to do? We're going to see this unfold over the next many years, 5 to 10 years. We're going to see a lot of stuff happening, and it's going to be a rapidly moving regulatory landscape. So I think the wrong question is to kind of sit back and say, okay, what are they going to do? I think for a company, they need to think about what should we do so that we're in a position that no matter where the regulation goes, that we can adapt to it and we can follow it, and I think that goes back to some foundations for ethical data governance, at least in the AI stuff with privacy. And I think the stronger the program is, and the more depth that companies can do that, the better position they're going to be for whatever direction things go. I think it's always better to be a leader than to kind of sit there and kind of wait till the regulators are going to knock on your door, and then it's retrofitting things, because it might be that maybe there'll be a fine, or maybe there'll be whatever, but that's not going to be the real big cost. I think companies don't underestimate retrofitting things to get to a spot where they kind of should have been or need to be is incredibly costly, and it's going to slow things down, and that's going to hurt innovation and take a lot of time and effort. That why not do it proactively and be ready? And we know a lot of things for good data governance, so why not do them now? Would be my
There's a
advice.
roadmap. I mean, the California AG, the Oregon AG gave you a roadmap. The EU Garantes Act, investigations, CNIL, the EDPB. There's all these things that you already know kind of which way the wind is blowing.
Let's make sense of them. And 2025 is going to be a difficult year, so I definitely recommend following, especially Dan and Alexei. Well, and also please follow me on LinkedIn. You guys are my favorite meme and cartoon creators. So through all the headache that we're going to be experiencing implementing various requirements, it's always nice to have a sense of humor in all of the process. So.
All right. Well, thank you both. This has been a wonderful conversation. I could go hours longer, but we've got to stop somewhere. And anyway, thank you so much for joining me.
Sure.
Thank you, Dan.